questions for Representative Palumbo? Thank you. Also on the list, we've got Catherine Godin, Stephen Brown, ACLU, and Liz Earls. You may proceed.
Good evening. My name is Kate Godin. I do criminal defense in Rhode Island and Massachusetts, and I focus on representing sex offenders. I also represent them at their classification hearings in Rhode Island and Massachusetts. And I'm here on behalf of myself as a criminal defense attorney, as well as a member of the Rhode Island ACLU. I'd like to point out that the numbers can be a little bit deceiving. While it's true that we may stand to lose 10% of our burn grant money, and I've heard figures from anywhere of 80,000 to 200,000, there have been studies done, and I believe Steve's packet that he will be providing to you has a copy of that study, said that in 2009 the estimated cost of first-year implementation of the Adam Walsh Act would be $1.7 million for the state. And I understand that there's been a $200,000 grant that will be provided for implementing the database, but obviously that doesn't really compare to $1.7 million. Also, in taking a step back, I understand that this may be suggested to be more efficient. I would say that if we were to eradicate a paper system and go to an electronic database, that probably would be more efficient, but that does not go as far as this proposed legislation suggests. What this does is it completely eliminates the current system and replaces it with another one. As Joey said, it's offender-based. So regardless of whether the circumstances suggested that you molested 12 children or one child, you're classified the same kind of risk to the community. And I think that can be misleading, because it's my understanding that under the current proposed legislation, statutory rape is the same level as a rapist or a child molester. So you have someone who's 19 years of age who has sex with his 15-year-old girlfriend. They're going to be required to register every 3 months for the rest of his or her life, and will be seen as the same risk level as someone who has molested a dozen children. So I think it's doing a disservice to the community, because it really doesn't take into effect and account the substantive issues, whether they have participated in treatment, whether there were extenuating circumstances to the offense. It's also, in my opinion, going to lead to a lot more defendants taking their cases to trial instead of pleading, because they will know of this registration requirement, which is going to mean a deeper burden financially for the criminal justice system and the court system. The retroactivity of it, as Joey was mentioning, if somebody committed a sex offense 40 years ago and is currently on a suspended sentence for, let's say, simple assault, this Department of Public Safety will have to look at every single person who's currently or in the future going to go through the criminal justice system to figure out whether they need to register as a sex offender. That, I would suggest to you, is going to be a prohibitive cost. It's also going to be a cost to our state to go after those who fail to register, to fail to comply with these very strict registration requirements. And that's going to cost the state money in prosecuting and housing these men, and sometimes women, that have failed to register or failed to maintain their registration requirements. Now, there are constitutional problems with this legislation. I would suggest that it absolutely violates due process. Our current system isn't perfect, but it at least provides the offender with an opportunity to suggest that his or her classification level does not appropriately fit or meet his risk. Under the current or the proposed system, you have absolutely no opportunity to challenge what classification level you are. It is completely offense-based. So if you had a reason to contest it 30 years ago and you thought nothing of it now you will have absolutely no opportunity to contest why you were given that conviction and what level you are now assessed at. And I would ask that you just take a look at the written testimony that I will be providing to you, most sex offenders they're not the strangers lurking in the bushes. Over 90% of all sex offenders know their victim before they commit the crime. So I would suggest that it would be a better use of our money to educate the public as to these sex offenses that are occurring, how it occurs, how we can prevent it, and educating the public instead of scaring them with these classification levels that, frankly, I don't think are appropriate. So I'm available for any questions.